Hi, welcome to the Children and Family Law Nuggets. I'm Chris Aniche, a specialist accredited children and family law solicitor practicing in London. I'll be discussing the court and child protection. I'm sure you will recall when we discussed child abuse in our penultimate section of our Children and Family Law Nuggets. We talked about 4 types of child abuse. Now we'll be discussing how the court treats the issue of child abuse and how it may lead to a child or children being removed from the care of their parents if a court rules that the child is suffering harm or likely to suffer significant harm as a result of the care being provided by the parents. When the court determines that a child has suffered harm, and if the harm is significant enough to warrant the local authorities' intervention in private family life and to share parental responsibility with the parents, this can only happen when the court makes a care order. When a care order is made, the LA shares parental responsibility with the parents or any person who has PRO, as is usually referred to. Please note, when the LA shares PRO with the parents, they are usually in the driving seat, meaning they make all the important decisions about that child or the children. That means they have the overriding parental responsibility according to Section 33 of the Children's Act of 1989. Decisions like the school the children would attend, contact arrangement with the parents if these children are already placed with the local authority, decision on medical treatment or other plans for the future. When the local authority shares parental responsibility with the parents, it is usually a prelude to the children being taken into the local authority's care, and in some situations, losing their children to adoption in future. In case you do not know, when there is an adoption order in place, the child is now the child of a new adoptive parents forever. This is a clear case of a child changing his or her identity in law forever. I'll be discussing about adoption in one of my future episodes. However, the reason I have raised adoption here is because it's important or it's pertinent that parents understand the severity of how the court takes child abuse, most especially when the child has suffered harm in the care of their parents or the caregiver. A parent can always prevent the making of a care order or local authorities' involvement in their family when they put the interests of the children first. I certainly will be discussing how to put the interests of your children first in another future segment. Now we'll discuss the law. The Children's Act 1989 is one of the crucial laws introduced to protect children in the United Kingdom. The law introduced the concept of significant harm as the yardstick that justifies the compulsory intervention in the family life in the best interest of the children. Under Section 31 of the Children's Act of 1989, a court may only make a care order, that is, committing the child to the care of the local authority, or a supervision order, putting the child under the supervision of a local authority or social worker, if it is satisfied that the child has suffered significant harm. The judge or the court can make a care order or supervision order if the following are in place. They are satisfied there is an evidence, that is the threshold criteria, which proves on the balance of probabilities that the child is suffering or is likely to suffer significant harm. Also, significant harm in future. And this significant harm will be as a result of either bad parenting, likely to be seen as the parent's fault, or the child is beyond parental control, which may not necessarily be seen as the parent's fault. There are two absolute criteria on which to rely when judging what constitutes significant harm. Consideration of the severity of the ill treatment may include the degree and the extent of physical harm, the duration and the frequency of the abuse or neglect, the extent of the premeditation, the degree of threat and coercion. Also, evidence of sadism and the bizarre or unusual element of child sexual abuse. When judging what constitutes significant harm, it is necessary to consider the family context, including the family strengths and the supports, the child's development within the context of the family and within the context of the wider social and cultural environment of the child. Any special needs, such as a medical condition, communication difficulty, disability that may affect the child's development and care within the family. The nature of harm in terms of the ill treatment or the failure to provide adequate care. Also, important information like the impact of on the child's health and development. Things also like the adequacy of parental care. Now talking about harm, it is important to discuss what is harm, what signifies what is significant harm? Section 31(9) of the Children's Act tells us that harm is ill treatment or the impairment of health or development, including, for example, impairment suffered from the seeing or hearing the ill treatment of another. The last part of being exposed to someone else being badly treated was added by Adoption and Children's Act of 2002. It was intended to cover such circumstances as a child who witnesses or hears someone else being hurt. For example, if the parents are fighting or shouting at one another at home, and this child witnesses it. Okay, turning to the other element of harm under Section 31(9). Development means physical, intellectual, emotional, social, or behavioral development. Health means physical or mental health. Ill treatment includes sexual abuse and other forms of bad treatment which are not physical. This includes emotional harm. This is the category of harm which is most common. Unfortunately, there is no definition of what is significant, that is significant harm. While Section 31(9) tells us what is meant by harm, but it does not give us a definition of what is meant by significant harm. However, Section 31(10) refers to the children's or the child's health and development being compared with that which could be reasonably expected of a similar child. This is an objective test which the court uses. We can get further guidance from looking at Article 8 of the European Convention on Human Rights, which is ECHR. Article 8 exists to protect our rights to a family and our private life. Article 8 makes it clear that the state can only interfere in family life when to do so is lawful, necessary, and proportionate. Proportionate is the key concept in family law. A one-off incident or less extremely serious, such as physical attack or sexual assault, is unlikely to justify the making of a care order, as the court will be unlikely to agree that a single incident will have a long-lasting and serious impact on the child. But the same type of incident repeated over time may well have very serious consequences for the child. There are some useful judicial decisions about what is significant harm. In the case of MA, care threshold decided in 2020, what LG stated that the harm must, in my judgment, be significant enough to justify the intervention of the state and in disturbing the autonomy of the parents to bring up their children by themselves in the way they choose. Also, in another decided case, decided by Baronet Hay, as she then was, in Ribi, Children, 2008, she stated as follows: taking a child away from her family is a momentous step, not only for her, but for her whole family and for the local authority, which does so. In a totalitarian society, uniformity and conformity are valued. Hence, totalitarian states tries to separate the child from her family and mold her to its own design. Families in all their subversive variety are the breeding ground of diversity and individuality. In a free state, democratic society, we value the diversity and individuality. End of quote. She also commented that the child is not the mere creature of the state. The harm has to be attributed to a lack or likely lack of reasonable parental care, not simply to the character and personalities of both the child and the parents. So once again, the court should identify how parental care is failing or is likely to fall short of what it will be reasonable to expect. The key here is what is reasonable in the eyes of the court or in the eyes of the law. There are two-stage tests in care proceedings in order to justify the making of care or supervision order. The court must satisfy a two-stage test. The first stage test is the threshold stage. There must be enough reason to justify the making of a care or supervision order. Or in other words, the case must cross the threshold. This threshold can only be crossed if the court agrees that 1. That things have happened which have already caused significant harm to a child, e.g. an unexplained injury on a child, for instance, bruising found on the child's body, which the parents cannot explain how it happened. Also, exposure to the risk of significant harm, present or future, e.g. a child who is witnessing serious domestic violence perpetrated by one of the parents on the other. As you are aware by now that DV is an emotional harm to a child who witnesses it. When a child is beyond parental control, e.g. a 14-year-old child who is tranting instead of being in school and the parents can no longer control him or her. Please note, it is only when the court decides that threshold has been crossed that the court can proceed to the second stage. If the court decides that threshold has not been crossed, the case must immediately come to an end without an order being made with respect to this family. However, if the court decides that the threshold has been crossed, then it will proceed to the next stage, which is called the welfare stage. The welfare stage is when the threshold is crossed and the court would have to decide What is the best means of safeguarding the child or promoting this child's best interest? If an order is required or not, the court will have to decide. In most situations, if the child has suffered significant harm, it is possible that the court will make an order if it is in the child's best interest. In summary, if the threshold is crossed, the court can do the following. Make a care order placing the child in the long-term care of the local authority. 2. A care order with a placement order under Section 21, Adoption and Children's Act 2002. This is the initial stage before adoption is made. Or 3. The child is returned to the parents under a supervision order. 4. Returned to the parents under no order but with tightly written agreement in place. 5. There might be a special guardianship order or a child arrangement order. Both of these I'll be discussing in a future segment. I hope I've been able to demystify some of the legal concepts around this highly controversial area of family law. I hope you've learned a lot from this segment on what is harm and what constitutes significant harm. You've also learned about what is threshold criteria and finally the powers of the court to make an order. Our next topic will be how to work with social workers when they are involved with your family to have a greater chance of keeping your children in your care. As always, I'm Chris Aniche, a specialist accredited children and family law solicitor. I practice in London and my details will follow after this video in case you have any question for me. Before I leave you, I would like to quote from Dr. Kofi Annan, who was the former United Nations Secretary General relating to children, and I quote, "There is no trust more sacred than the one the world holds with the children. There is no duty more important than ensuring that their rights are respected and that their welfare is protected, that their lives are free from fear and want, and they can grow up in peace." Thank you very much. See you in my next segment.